The second issue before this court is, does Section 19253 require that when electronic votes are recounted, that the VVPAT paper ballots be recounted for a recount to be legally deemed to have occurred? Section 19253b1 clearly and unambiguously requires that VVPAT paper ballots, quote, shall be, quote, used for any full recount. Thus, the trial judge, in order to reach the result he did, had to ignore the words shall, the words used, and the words any in the statute. This violates the provision of CCP 1858. The trial courts are prohibited from omitting what has been inserted. Despite the fact that the section states that the VVPAT paper ballot shall be used for any full recount, the trial judge upheld the recount where it is beyond dispute that the VVPAT paper ballots were never used in any way for any purpose during the recount. They sat safely in their sealed little boxes in the back. Despite the fact that the statute requires that the VVPAT shall be used for any full recount, the trial judge rewrote the statute to cause it to only apply to a single type of recount, a manual recount, when in fact we know from 15627A there are two kinds of recounts, a manual and by means of the voting system used originally. In order to get to this ruling, the trial judge based this on three findings. Quote, he stated, quote, if you read Section 19253 literally, any recount would have to recount the VVPAT votes. He goes on to state, quote, this contest turns on these two sections, 15627 and 19253, and it appears to me that there's a conflict between the two, and he concludes by stating, quote, it would be easy to reconcile the two if you simply read B1 to refer only to a manual count having to do with the DRE voting. Now, with respect to the trial judge, I believe he violated two clear rules of statutory construction. First, as the California Supreme Court stated in Bay versus City of Fontana, it is presumed that the lawmakers meant what they said, and quote, the plain meaning of the language governs, if the language is plain. And here, keep in mind, he ruled that the language was very plain. He understood what it literally told it to do. He simply didn't like the result. Second, the trial judge violated the principle set down by the California Supreme Court Gay Law Students Association that, quote, effect should be given to every word and every clause thereof, leaving no part of the provision useless or deprived of meaning. The statutory construction that we bring to this court is the only construction that takes all of the statutes and gives them full meaning. It doesn't find any inconsistent, it doesn't limit any of them. In order to get to the statutory construction that is urged by the respondents, you have to severely limit 19253. You have to eliminate the legislature's directive to protect against electronic voting. And you have to read 19253b2 out of the statute completely, because it was passed entirely for the purpose of dealing with the two counts that would occur if you do a count by a voting system used originally on DRE votes. You're always going to get your MVD count, and you're always going to get your count on the VVPAT paper ballots. Well, sometimes those are going to be different. And the legislature specifically and consciously anticipated that, and they passed a law to deal with that. They passed a law that said, in those circumstances, the paper ballot, we're going to create a legislative presumption in favor of those will control. That statute disappears if you adopt the construction urged by the respondents.